Hello, everyone. Thank you so much for joining us today. So if we can get started on the presentation now. So to understand private offerings, we also need to understand how a startup works, or what are the different stages that the startup goes through. So a startup, as we know it, typically they come up with some brilliant business idea, and they are looking to get their operations up and running. And the initial funding, the promoters might have put in their entire life savings into it, and might even take some help from their friends and family initially. Now, this is what we call a pre-seed round, where there may not be any return for equity, any return of equity, sorry. And if the company continues to do well, they might have a prototype, and they might be looking for more funding, say for research and development, or maybe to file a patent, which can be expensive. And at this point, if they're raising funds, this would be their first official round of funding, and this is known as a seed funding round. And the actors of seed funding round are typically founders, friends and family, incubators, which are basically some organizations that allow for these startups to grow and may even invest in them. And some venture capitalists may also come into this play. And in seed funding rounds, a company typically raises anything between $10,000 to about $2 million. And the reason we're trying to learn the different rounds is because we're going to negotiate, the terms of the agreement are negotiated depending on at which round the investor is coming in. So if the company is continuing to do well and not just has great ideas, but also has some strong strategy to turn these ideas into profitable businesses, and they're looking for additional funding, that is when what we call a Series A funding comes in. And the companies typically raise about between $2 million to $15 million in these Series A rounds. And they're led by venture capital firms, and may also have some angel investors. And the companies may follow it up with Series B and Series C, and may ultimately end up in an IPO. So the reason I discuss these rounds is these rounds are what constitutes a private placement. So a private placement is a sale of stock or bonds to pre-selected investors and institutions rather than on the open market. It is an alternative to an initial public offering for a company seeking to raise capital for its expansion. And the investors can be both individual or institutional investors. Private placements are relatively unregulated compared to sale of securities in public market. And these private placements are commonly used by startups so as to raise funds that they need to grow while delaying or foregoing an IPO. So the advantages of private placements are that they have less burdensome regulatory requirements. We'll go into what regulatory requirements govern them in the next few slides. And they can be done at a reduced cost and time. So if the typical age for an IPO is between 3 months to 6 months, a private offering can be done in less than a month. And they will give the issuer the ability to remain a private company. So they're not overly burdened by, say, the stock exchange reporting requirements, and they can continue to operate at their the way they think is right for the company. Now, coming to the regulatory framework, the sale of securities in the public market is regulated by the Securities Act of 1933. Now, this act was enacted after the market crash of 1929 to ensure that the investors receive sufficient disclosures when they purchase securities. In general, all securities offered in the US must be registered with the SEC. The registration forms that a company files with the SEC, they provide for certain essential facts, which include a description of the company's properties and business, a description of the security to be offered for sale, information about the management of the company, and financial statements certified by independent accountants. However, there is an exemption from this registration requirement. To qualify for an exemption, typically an offering must be a non-public offering, and it should be that there cannot be any general solicitation or advertising, and it should be made to a limited number of offerees. The investors should be buying for their own investment and not with a view to distribute the shares further. And the investors must be sophisticated investors at least, and should have been provided with or have access to certain information about the issuer. So Reg D of the Act is a safe harbor and provides a specific registration exemption for private placement offerings. Companies that comply with the Reg D requirements do not have to register their securities with the SEC, but they must file a Form D electronically within 15 calendar days of selling their first securities. Now, Form D is a brief notice that includes the names and addresses of the company's promoters, executive officers and directors, and some details about the offering. Now, moving on to the types of private offerings. So for decades, companies wishing to sell securities had to rely on friends and family or their own networks because securities laws didn't allow for general solicitation. But that changed in September 2013 when Jobs Act came into effect. The Rule 506 exemption. Now we'll speak about what this Rule 504 and 506 are. And there used to be something called a Rule 504, which was taken away by this act. That is, they cannot be sold for at least 6 months to 1 year without first registering them. Now, a Rule 504 offering, it exempts offering in which issuers offer or sell up to 5 million in securities in any 12-month period. This used to be 1 million and it was increased to 5 million. And the Rule 505 I was talking about was the rule that allowed up to 5 million, and that was completely scrapped. So they made this $5 million offering. So if you have a client who's coming to you and is planning on raising about 2 million, so this would probably be the first rule you would consider because it has certain advantages to it. And if you compare Rule 506B offering, so issuer may raise an unlimited amount of money under this, and the same goes for 506C. So up to 5 million is 504. Anything over and above 5 million comes under the purview of 506B or 506C. Now, moving on, Rule 504, it permits general solicitation and advertising, but it is subject to certain state regulations. And I'll tell you why in a minute. And Rule 506B, it does not allow for general solicitation. So you cannot have any kind of solicitation under 506B offering. Whereas 506C, which is the new rule, also allows for solicitation and advertising. And this is because 504 allows for unlimited number of investors, accredited or not, only subject to certain blue sky limitations. So there are non-accredited investors, meaning these are, I'll explain what the definition of accredited investors is in a minute. So these investors are vulnerable and they may not have as much information about the offering or the company, or may not have financial expertise to assess what is right and wrong. But because the offering is only up to 5 million, there's less at stake, and SEC thinks that it's okay if this offering is at risk. It doesn't want to. It weighs the option of whether or not the company is under more burden by having reporting or having a disclosure document versus how much is at risk here for the non-accredited investors. Now, 506B offering may be sold to unlimited number of accredited investors, but up to only 35 other investors who are otherwise known as sophisticated investors. Now, this term sophisticated is an industry term. And it refers to those investors who must have sufficient knowledge and experience in financial and business matters to make them capable of evaluating the merits and risks of the prospective investment. So because this allows for non-accredited investors, that is why there cannot be any general solicitation or advertising. And because the stakes are high, it's more than $5 million that the company is raising. And under 506C, all investors must be accredited investors. So because they're all knowledgeable and supposedly experts in finance, the SEC doesn't mind that a company solicits these investors. And moving on, Rule 504, investors must self-verify whether or not they are accredited investors. So we usually draft something called an investor questionnaire and share with the company, and the company will forward this to the investors, and it will have a variety of questions asking them about their net worth and their income. And this is sort of a self-certification by the investor themselves saying whether or not they are accredited. And this is sufficient for Rule 504 purposes. And 506B offering, the investors must also self-verify, just as 504. But 506C, because these are accredited investors, the company the burden is on the company to actually take steps to ensure that this investor is indeed an accredited investor. So the company may ask for documents from this investor to verify. It could be their W-2s, tax returns, or bank and brokerage statements, credit reports, etc. The company need not provide any disclosure document to non-accredited investors under Rule 504. So therefore, you don't have to. So you don't have to provide a disclosure document, but it is recommended and advisable that you do provide some amount of disclosure, especially any material non-public information to all your potential investors. 506B offering, it requires a disclosure document because you are issuing to non-accredited investors. And you must disclose information such as financial statements or any type of information that you provide in registered offerings. Although there is no requirement to provide any information to accredited investors, it is advisable that you maintain uniformity in your information dissemination and provide the same information, and also arrange for a Q&A session with your investors so that they have an opportunity to ask the company the questions or regarding the investment. Okay. So about the 506C offering, so there is no requirement to provide any disclosure document to accredited investors because they are assumed that they would have done their due diligence and would know some information about the company. So you don't have to. The only rule under which you are mandated to provide an offering memorandum is under 506B. Now, I've spoken about who an accredited investor, and so there is a two-part test. It's a net worth and an income test. So if an individual owns or has a net worth of $1 million, not including their primary residence, they can be considered an accredited investor. Or if they have an income of over $200,000 in a year, and for the last 2 years, or a combined income of $300,000 with their spouse if they're married for the last 2 years, and are expected to make the same amount of money this year as well, they may be considered an accredited investor. Now, the problem with this definition is that it does not consider the actual financial sophistication of the investor. So following this net worth and income test, I'll give you some examples of individuals who would be considered accredited. So one could be a single working parent of 3 children with an annual salary of, say, $205,000 a year, and also has, say, a home mortgage to pay. So they may be considered an accredited investor. Or a recent widow who, say, inherited $1 million but does not have a separate income for herself. also is deemed an accredited investor. Or a senior retiree who has accumulated over $1 million in his or her retirement account and needs that money for the retirement years. Now, just because they have $1 million, they may be considered an accredited investor. Now, you see the problem with this definition. It actually doesn't consider whether or not they have that financial sophistication to make that decision of whether an investment in a company is good or not, or whether they can assess their financial statements well and come to a good investment decision. Now, while these individuals qualify as accredited investors, there is nothing in the definition that helps identify their financial sophistication. Moreover, as the SEC's Investor Advisory Committee has pointed out, the current accredited investor definition may be under-inclusive because potential investors who most people would consider to be financially sophisticated, such as a chartered accountant or a graduate professor of, say, corporate finance, may not have the income or the accumulated net worth to be eligible to be accredited investor, but they may actually be in a better position to protect their own interests. So these people are what they call sophisticated investors. Some other exempt offerings that you should know of are the Reg S offering, which is a foreign offering, say, made in India, but no nexus to the US. That is, the offer or sale must be made in an offshore transaction, and there must be no direct selling efforts in the US. So, for example, a transaction that is executed on a foreign securities exchange located outside the US, in particular, if the foreign issuer must be careful with that any publicity that they do, such as press releases, used in connection with such foreign offering should be restricted from dissemination in the US. Otherwise, they would be considered directed selling efforts. And the release of, so practically speaking, there should be a legend in these advertisements making it very clear that they're not intended for US distribution. And the second type of offering that we come across is a Rule 144A offering, which, 144A exemption, which provides for an exemption for a resale of privately placed securities to certain qualified institutional buyers, or QIBs, that are deemed sophisticated investors. Now, there are two steps involved. One, there should have been a private placement already, and two, there should have been a resale to a QIB. Now, a QIB can include a US regulated insurance company, investment company, or certain employee benefit plans, trusts, etc.
So I believe we have discussed about all the exemptions, but from practical side, we always need to remember there's no exemption from anti-fraud provision. So which means all securities transactions, even exempt transactions, are subject to the anti-fraud provision of the federal security laws. So this means that if you made any false statement, or if you made any incorrect or purposely omit any material facts, you will be liable. Even your company, if somebody from your company on behalf of your company made the false statement, the company will be also liable for that. So the government and the private parties both can bring actions under the security laws. The security laws prohibits both fraudulent conduct, both criminally and civilly. So there are also definitely the remedy for it. So if all the conditions of the exemption are not met, the purchase may be able to get their purchase security back and get a refund of the purchase price. So from the government perspective, what they can do is the commission, in a case filed in the United States District Court, the commission can obtain an order and enjoin the individual from further misconduct, and also suspend their license. So there's definitely the remedy, and in some circumstances, there also can be civil penalties. So basically, it shall be unlawful for anybody by any methods, use any way to defraud or make untrue statement, or, as I said, materially omit any material effect in the transaction, the purchase of any securities. So under this rule, which is very important, there's also a very interesting and famous case I would like to share with you guys. even he is not the maker, but still can be liable. So practically, we need to really careful about this, and also to make the notice of the client, because state law also protect the rights of the investor. So the state anti-fraud regulation also require the issuers of security to be registered and to disclose the detail of their offering. And if the state law is totally copy the federal law, then there will be assumption that the law is valid. And the mandate license for the brokerage firms, investment advisor, and individual brokers offering security in their state. And finally is the issuer also need to make the notice and filing and pay the filing fee. So they also need to make the filing with the 15 days, as Chetana previously said, after first sale in the state. And because of failure to do so is also the remedy to get a fine, which is the civil penalties, or repay the funds. So I think that's all for the state and the federal anti-fraud provisions.
Thank you all. Thank you so much for attending this.